Hello everybody. So this is our second lecture in this series of free MCQs. Earlier one lecture is already we have completed, that was regarding the fundamental rights. So we have taken few questions regarding the fundamental right in a previous lecture. If you haven't seen it, please see it. So here we are going to talk about the MCQs regarding the chapter of direct principle of state policies. So this series just started, it will go on. We are taking so many chapters and different questions, important questions will be discussed. We will take also previous year questions, the PYQs will also be covered. And after some time, we are going to start with Indian Polity English medium series also. Okay, right now Indian Polity Marathi series is already going on. So we will start with the Indian Polity English series also. If you understand the Marathi, so you can watch those lectures also, Indian Polity Marathi lectures. Otherwise, English lectures also we are starting. Okay, so today in free MCQ series, we are starting with this chapter, Direct Principle of State Policy. So we will see some questions, some answers are also there, model answers are also given. We will discuss it. So the first question is, the principle enshrined in the Direct Principle of State Policy can be classified into which of the following? So we know there are three classifications. The DPSPs are divided or classified into the three parts. So here it is asking which are those three. Okay. So options are socialistic principles, Gandhian principle, liberal intellectual principle, and international principle. Four are there. So we know that DPSP are divided into the three parts. Which are these three parts? First three: socialist, Gandhian, and liberal intellectual principle. So here option is 1 and 2 will be wrong, 2, 3 will be wrong, 1, 2, 3, 4 will be wrong because there is no international kind of a principles. Yes, Article 51 of DPSP talks about some international principles, but there is no separate category, no separate classification about international principle. Okay, so D is the answer 1, 2, and 3. So D is our answer. Explanation here is given that Constitution does not have any classification. Actually, direct to principle, Constitution does not have, but on the basis of its content and direction, we have classified it into the three parts: socialist, Gandhian, and liberal intellectual. But this first sentence is also important. This classification is not mentioned in the Constitution. Okay, that's important. Like fundamental rights, we know like the rights about equality or right related to freedom, then rights against exploitation, then religious rights, minority rights, rights for constitutional remedies. These are the divisions in fundamental rights which are mentioned in the constitution. Like such classification is not there for DPSP, but still we have classified into socialist, Gandhian, and liberal intellectual. And see the second question, read it. Which of the following statement is correct? So some three statements are given here, so we have to find out which statements are correct. Direct to principle aims at providing education to all children below the age of 14 years. Second is, unlike fundamental rights, the fulfillment of various direct to principle is depend on the economic capacity of the state. Third is, direct to principle cannot become the basis of labor reform. Say, there was Article 45 of the Constitution which was talking about this before. Like all children below the age of 14 years, they should be provided education. But we know 86 Constitutional Amendment Act that happened, and this is shifted to Article 21A of the Fundamental Rights. Right now, directive principle does not talk about education to all children below the age of 14 years because it is shifted to fundamental rights. It talks about providing a education or early education to the children less than 6 years of age now. Okay, so this first statement becomes wrong. Okay, first statement becomes wrong means the option A and option B definitely became wrong. Then second statement is, unlike the fundamental right, the fulfillment of directive principle is depend on the economic capacity. Definitely, they are not compulsory. So it is depend on the capacity of the state. If state is financially able to do this, then state will do that. But fundamental rights are compulsory. It does not depend on the capacity of the state. It has to be provided. Third is, directive principle cannot become the basis of labor reform. This is wrong. Okay, there are certain articles. We will see it in the model answer. With the use of that, government can make a policy for the labor reforms. So okay, so third statement is also wrong. So this became wrong, and only second statement is right. So option will be C. So right answer is C here. So as I told, Article 45 it is amended by the 86 of the Constitution. So first statement became wrong. And there are some articles like Article 43, Article 43A, Article 46. This becomes the basis of labor reforms. Okay, so that's why the option will be C. Third question. Which of the following institutions adopt the principle of directive principles of state policy while formulating and enacting laws? Formulating and enacting laws. Which institution use DPSPs for this purpose? So your options are given: legislative, judiciary, local authorities, public sector enterprises. So it may happen that you may think that all can use directive principles of state policy. Definitely all can use it. But here the statement is given while formulating policies and enacting laws. Does judiciary formulate policy or enact the laws? No. Judiciary does not formulate policy. Judiciary does not enact laws. It gives meaning to the laws. It gives meaning to the constitution. Okay, that's why two will not be there. Here it is two, this will not be answer. Here it is two, this will not be answer. So either one or 134. Local authorities and public sector enterprises, they can formulate policies. Okay, definitely that's why 134 will be our answer. 2 will not be answer. Why? Because judiciary cannot formulate policies. They don't formulate, executives formulate policies. And who enacts the laws? Legislature enact the law. So that's why judiciary will not be there. Okay, so that's why the answer will be C here. There is no need of model answer here because you just have to take this option out. So you will get the answer. Then question 4. What it is saying? Which among the following was where the reasons behind the making directive principle non-justiciable and non-enforceable, legally non-enforceable by the makers of constitution? It is asking the reasons why it is not made justiciable or not enforceable. So first option is lack of financial resources in the country to implement them. Second, implementation challenge due to vast diversity and the backwardness in the country. Third, making them justiciable would widely increase the power of courts and judiciary. The fourth one, the newly independent India should be free to decide in order the time, the place, and the mode of fulfilling them. Okay, so first thing, lack of financial resources. Definitely India was having the financial resources, lack of financial resources. Right now also we face this problem. That's why it has not made for enforceable. Because if it has been made for enforceable, what will happen? Government has to do that. And what if the government doesn't have money? Okay, so definitely that will lead to the violation. That's why it has not made non-enforceable. Has been made non-enforceable. Then implementation challenge due to vast diversity. Definitely there is a vast diversity in the backwardness in the country. So we need to deal very carefully with citizens. That's why it has not made non-justiciable or non-enforceable. Third, making them justiciable would have widely increased the power of courts and judiciary. This cannot be the option. It doesn't matter if it is giving powers to the court and judiciary for the sake of welfare of the people, then it would not have been the matter. Okay, we also know that for the fundamental rights, we have made them justiciable, we have made them enforceable. It has increased the power of courts and judiciary for the fundamental rights. That doesn't harm any interest of citizens or the interest of executives or the legislatures. So that this cannot be the option. The fourth one, the newly independent India would be free to decide the order, the time, the place, and the mode of fulfilling. Right. The newly independent India needs the time. Okay, once everything gets settled, because when we got independence, we have different problems. Okay, so we have to integrate complete India, just partition happen, and linguistic reorganization, and the poverty and the agriculture backwardness. So many things we had to deal. Okay, so in newly independent India need time to deal all this issue which are mentioned in the DPSP. So definitely it cannot be made justiciable or enforceable. So only third option cannot be there. So 1, 2, 4 will be our answer. D will be our answer. Same options has been given. Newly independent does not have the sufficient financial resources. There is a vast diversity and backwardness. Okay, there were so many issues that has to be dealt at the time of independence. That's why we have not made them justiciable or enforceable. Then the fifth question: which of the following judgment amendment pronounce the balance between directive principle and the fundamental rights? So earlier there was a conflict which was going on between the fundamental rights and the directive principle, which will be better. There are cases earlier that happened, like Golaknath case or other cases that happened. So there was a problem with respect to the fundamental rights and directive principle. Even Keshwanand Bharati case could not solve it. So there is one case. In that case, the Supreme Court said that no, no one is better. Like no, neither fundamental rights or directive principles, they are above each other. There is a balance. There is a fine balance between them. They are complementing each other. Okay, they are not competing with each other. So which case was that? We should know. It's a Minerva Mill case. It's a direct answer. It's the Minerva Mill case. Okay, C is the Minerva Mill case. C is the answer. Minerva Mill case. In this case, the Supreme Court has said that there is a balance between the fundamental rights and directive principle, which led to rest the conflict between these two. Earlier, there was so much of conflict which was going on. Okay, that conflict led to rest because of this judgment. Okay, so thank you so much. If you liking this series, please subscribe the channel and like this video, comment on this video. If there are suggestion you want to be, you can definitely give the suggestion. And if you think some person is needy and some person need to know all these things, need to get benefit of this series, please share this video with that person also and ask him to subscribe. Okay, so the more subscribers will be there, more views will be there. I will also get the motivation to start new things for you. Okay, and to prepare videos frequently and all that. So it's a mutual benefit, so let's do it. Okay, thank you so much.